So, good evening, everyone. Let's get started. I'm Dr. Tim Bowley. I'm a lawyer and corporate law academic and a visiting researcher at the Ross Parsons Centre in 2024. And I'll be chairing tonight's seminar. It's my pleasure to welcome you all to tonight's event, which forms part of the Downtown Law and Business Seminar program of the Ross Parsons Centre for Commercial, Corporate and Taxation Law at Sydney Law School. Tonight's seminar will be given by Professor Donna Nagy and Associate Professor Juliette Overland, and is titled Insider Trading, Fiduciary Relationships and Market Integrity, the Comparative Consideration of the Insider Laws of the United States and Australia. So let me introduce our speakers. Professor Nagy is Executive Associate Dean and C. Ben Dutton Professor of Business Law at Indiana University Maurer School of Law. She teaches and writes in the areas of securities litigation, securities regulation, and corporations. She's written extensively on the selective disclosure of government information, government officials and financial conflicts of interest, and insider trading and fiduciary principles. Prior to commencing her academic career, Professor Nagy worked at the law firm Debevoise and Plimpton in Washington, D.C., specialising in securities enforcement and litigation. Our other speaker tonight, Associate Professor Juliette Overland, is from the University of Sydney Business School, where she teaches and researches in the area of corporate law, particularly the regulation of securities markets, insider trading, and corporate crime. Professor Overland's research examines issues concerning corporate liability for insider trading, the effectiveness of insider trading regulation, and the relationship between corporate governance and insider trading. In addition to her experience as an academic, Professor Overland has extensive practical experience as a corporate lawyer, having worked in leading Australian law firms and as Australian legal counsel for a global technology company. Now, the format of tonight's seminar is that Professors Nagy and Overland will talk for about 40 minutes, and then we will have around 15 minutes for Q&A. We'll aim to wrap up the session at 7 p.m, and we can then continue the conversation over some food and drinks at the back of the room. So, on that note, I will turn the microphone over to you.
Thank you very much for the warm welcome. And I do want to acknowledge that we are on the land of the Gadigal people of the Eora Nation on unceded land. And I thank the custodians of the land for their care for this country over time. I'm very pleased to be presenting with Donna today. And it's a real pleasure to be able to present a joint paper with such an esteemed international academic. And Donna is very highly regarded and recognised for her work. So for those of you who don't know Donna and her work, it's a pleasure for me to have worked on a project like this with her. So the work that we're going to present to you today arose out of a project that we undertook starting prior to COVID. And then with the lockdown, we spent many hours on Zoom discussing our work and our project. And it was a time that I was really grateful we had, that capability to conduct international comparative work that would normally only be possible in person. So I'm going to just give you a brief description of what we're going to talk about for the next 40 minutes. And we will move back and forth a bit between the two of us. But what we'd like to share with you is, first of all, a discussion about what are the differences between the way in which Australia regulates insider trading, and particularly looking at the reasons why it's prohibited. And one of the things I find particularly interesting about any area of the law is thinking not just what does the law say, what does the law prohibit, but why does it do that? What is the reason for making certain types of conduct criminal conduct? What's the reason for saying certain types of activities shouldn't be engaged in? And then how does that impact on the way in which the law then exists? And when we're thinking about areas of the law, particularly areas like insider trading, that have a reputation for being difficult to detect, the legislation is difficult to understand. How does the reason why it's prohibited have an impact on those interpretations? And how does it impact on what we consider are the most serious types of misconduct? And then looking at what types of sentences do we give to people who are convicted of those offences, taking into account those types of issues. So we're going to talk about that in the context of both Australia and the US, and look at the different rationales and the similarities that exist, the differences that are there. And at the heart of this consideration is, to what extent are fiduciary duties, so those obligations to put somebody else's best interest, to have a relationship that has trust and confidence and confidentiality at its heart, how does that influence insider trading laws in the two jurisdictions? And for us, when we have looked at a variety of cases in this area, one of the things that really gave life to this project was being able to consider sets of offenders together. So when we could look at what we call tippers and tippees, someone who has information who passes it on to someone else is the tipper. The person who receives the information is the tippee. And there are a number of cases that have developed, particularly in more recent years, where both the tipper and the tippee have been accused of insider trading. And if we look at the different ways in which their conduct is treated by the courts, we can look at what are the most sort of serious or aggravating factors of what they've each done. And we have found that to be a really fascinating thing to examine when we then want to tie it back to what's the impact of the relevant reason for making insider trading a crime? What is the impact of a fiduciary duty or not that might have existed for the tipper but not the tippee? And then we're going to talk you through our overall findings and what we think this might mean for the future of regulation in both our respective jurisdictions and what they might be able to learn from each other. So what I'm going to talk about now might be more familiar to some of you, particularly because I'm assuming it's a primarily Australian audience here, but insider trading in Australia has an express statutory prohibition. So it's expressly prohibited by our Corporations Act, and it forms part of Chapter 7 of the Corporations Act, which is one of the largest chapters that the Corporations Act has, but it also is a chapter that has a reputation for being difficult to understand, not necessarily cohesively drafted. And for those of you who follow such things, Chapter 7 has recently been the subject of the Australian Law Reform Commission's inquiry into financial services and markets regulation, with a whole raft of recommendations around how to actually make that chapter easier to read, more logically set out. And the corollary for that is then it will make it easier to understand and interpret. So the four elements that I've set out for you here are not what you will find when you look at Section 1043A of the Corporations Act. These are my summary, which I hope is easy to understand, of where you will find the law if you move between Section 1043A, Section 1042C, 1042D, back again to A for some more interpretation. And my students will often say, if I show them a slide like this, oh, I had a look at the legislation. It doesn't match what you said. I said, no, because you had to go a lot further to actually find this. And a number of the judgments that we're going to talk about tonight include quotes from judges. I won't read all of those to you tonight, who actually say a serious criminal offence like insider trading should not be so difficult to interpret. People who are accused of a serious criminal offence should be able to more easily understand exactly what the legislation provides. But there are essentially four elements. So first of all, someone has to possess some information. And in Australia, the cases have interpreted that word possess to include some element of awareness. So just having a piece of paper in your briefcase that you've never looked at because someone else put it there, you might physically possess something that has something written on it, that's information, but you won't possess it for the purposes of these laws. So the statute uses that word possess, but really, I would like to see it say something like the person knows, the person has awareness of some information. Then that information has to have characteristics that make it inside information. It's not generally available, so it's not publicly available information, either People haven't been able to observe it. It hasn't yet been released to the market. So it's not something that's available to the general public. Maybe only a small group of people are aware of it. And it's information, if it was available, it would be material. So it would influence the price or value of a company's shares, securities, or other financial products. Then that person who possesses it knows that it has those qualities. So they know it's inside information, or they ought to know that. Perhaps they ought to know that because they work in a broking firm. Perhaps they ought to know that because of the circumstances in which they came to be told it, because the person who told them said, you mustn't trade on this because nobody else knows this. But then while they possess it, before it's made available, and while it's still material, that person either trades in relevant products themselves, procures someone else to do it, or, and this will be quite relevant to our later discussion, or they tip that information. They pass it on to somebody else who they know is likely to then go and trade or procure some trading. So for insider trading to exist in Australia, each of those four elements must exist. So when we then look at what's the underlying rationale, Australia now has what we like to call an information connection. So anyone who possesses that information and otherwise would fulfill those elements can be liable for insider trading. It doesn't matter if you don't have a connection to the relevant company. It doesn't matter who told you that information, if you received it from someone else, and whether they have a connection to the company or not. If you possess the information and it's inside information and you know that or should know that, and you still trade or procure trading or tip, you have liability. So there's no concern or requirement that you have any particular connection. Now, that arises from the fact that Australia prohibits insider trading on the basis of what we call a market integrity rationale. So applying principles of market fairness and making sure that there's equal access. Anyone who wants to trade should be able to find information that would impact on the value that shares or other securities or products have. And that was undoubtedly confirmed after most people had assumed that was the case anyway, in 2012 with the High Court decision, our only High Court decision on insider trading in Mansfield and Kyson. So that's accepted to be many different government inquiries, many different cases now, all accept that that is the reason why Australia prohibits insider trading, to keep the market fair. And beneath that rationale are principles that are considered to exist that if we didn't prohibit it for that reason, some people then wouldn't participate in the market. If they think that only people who can have inside information are going to be able to profit or be able to profit at their expense, they'll be less likely to want to make investments. Whereas if it's prohibited conduct and we have other techniques to try to make it less likely insiders can trade, there'll be greater market confidence, people will invest. That makes the cost of capital for companies who want to raise money cheaper. But another important aspect of the insider trading rationale here then is that there's no obligation that attaches to it for the person who has that inside information to make any particular disclosure. The obligation, if they possess it, is that they abstain from engaging in any of the relevant activities. Now, companies themselves may have disclosure obligations under continuous or periodic disclosure. They may be obliged to inform the market of something they know of that's going to impact on the price or value of their securities. But the actual individuals don't have an obligation to disclose, they have an obligation to abstain. So I'm going to pass over to Donna now, and she's going to talk to you about some of the similarities and differences for the US in this context as well.
Thank you, Gillian, and thanks everyone for coming. It's a true pleasure to be here. It's just wonderful to have the opportunity to present with my collaborator, who has since become a dear friend, and so this is really just a wonderful occasion. So, I'm going to talk to you about insider trading in the United States, and so which is very different in terms of how the U.S. approaches the regulation of insider trading. Interestingly enough, the policy rationales that Juliet spoke to you about, concerns about market integrity, concerns about equal access, concerns about investor confidence. If investors believe a securities market is rigged to those in the know, are they going to be willing to put their retirement monies in the securities market, or are they going to put it in a bank or a coffee can in the backyard? And so what propelled our Securities and Exchange Commission in the 1960s to bring enforcement actions is the very same policies that later in time, Australia seems to have sort of propelled into that. Now, we took a very, very different turn than you folks did in Australia. And our story starts in the US in the 1960s, where, so we do not, I'll start what we don't have. What we don't have is what you saw on the screen in terms of a statute that sets elements. And even though the elements may be in different parts, I envy that, because we don't have a statute at all that expressly prohibits the offense of insider trading. Trading while in possession of material non-public information explicitly is not prohibited in the United States. By statute. What is prohibited in the United States is fraud in connection with the purchase and sale or purchase or sale of securities. And that's an SEC rule that was adopted under the authorization of Congress, who in the Exchange Act of 1934 gives the SEC rulemaking for fraudulent practices. So in the 1940s, the SEC, without insider trading in mind, adopts a broad prohibition of fraud in connection with the purchase or sale of any securities. Years go by, in fact, decades go by. In the 1960s and 70s, lower federal courts, so district courts, and then the Second Circuit, which is where New York City is located. And so the Second Circuit, we have 11 federal circuits in the District of Columbia, are circuit courts. They began to recognize that insider trading was a violation of Rule 10b-5. So let's think about how that is, because typically when we think of fraud, we think of someone lying, someone making a misrepresentation. And insider trading is anything but someone lying. In fact, insider trading is all about silence. There's a person in the know, and that person stays mum to counterparties. Now, in an anonymous securities market, you typically don't know who your counterparty is, but it's so silence is the offense. You're staying silent about facts you know that would certainly make a difference to the person on the other side of the transaction if they knew those facts. Well, that can be fraud. Misleading silence under the common law is a type of fraud. And then the name of the game becomes, well, what type of scenario does just keeping quiet constitute deceit, constitute fraud? So in the 1960s and 70s, courts didn't really give a heck of a lot of thought to what exactly is the doctrinal fraud. Instead, what we see is a construction of Rule 10b-5 and an announcement in one of the key cases, SEC versus Texas Gulf Sulfur, which involved an ore strike. And so a good news, Texas Gulf up in Canada found ore and made the company lots of money, much more valuable. Insiders in Texas Gulf Sulfur, then knowing that information, went into the market, buying Texas Gulf Sulfur at a low price. And then, of course, when the ore strike was announced, their price skyrocketed. What the Second Circuit said in the Texas Gulf Sulfur case is that anyone in possession of material non-public information that stays silent about that information commits fraud in violation of Rule 10b-5 because there's a justifiable expectation in a securities marketplace that all investors have equal access to material non-public information. So the policy rationales that drove the Australia prohibition we see discussed in this Texas Gulf sulfur case. Then what happens? Years pass. Our Supreme Court, the first time that they grappled with market-based insider trading was in a case called Chiarella versus United States. And this was a financial printer who was working for the acquiring company who used code names. I guess this was like the Sudoku puzzle of the 1970s or so. And they blacked out the name of the target companies, but this financial printer who printed the documents was really sort of skilled at puzzles, and he was able to figure out the targets. And so he bought stock in the targets and made a lot of money, or relatively a lot of money. I mean, he was a printer, so it was thousands of dollars, not hundreds of thousands of dollars. And he was criminally prosecuted, the first criminal case of insider trading, on this sort of equal access. It was actually, in fairness, more of a structural access theory. The idea was that as a financial printer working for an acquiring company, he had structural access to material non-public information that everyday ordinary investors did not. And so convicted by a jury, went to the Second Circuit. The Second Circuit kind of dialed back a little bit this anyone idea, but said, no, as a financial printer, you have special access to information. You go to prison. The Supreme Court has the case then, and the Supreme Court, a divided Supreme Court, the majority says, no, deceit and fraud do not necessarily mean that anybody is under a disclosure obligation. The Supreme Court says that at common law, you only had that disclosure obligation, so your silence was only misleading in certain circumstances. And what the Supreme Court did is it seized on the well-known common law exception to the sort of caveat emptor rule, right to remain silent. You have a right to remain silent, except our Supreme Court zeroed in on a fiduciary relationship. And even though there wasn't a fiduciary relationship in the Chiarella case, and so in elaborate dicta, the Supreme Court said Chiarella's silence was not misleading because he was not under a duty to the counterparties, these anonymous shareholders in the marketplace of the target. He was not under a duty to disclose, so he could keep silent. But then the Supreme Court said, now, if he were an insider of the target corporation, if he were an officer, if he were a director, presumably even if he were an employee of the target, he would have had a fiduciary-like duty of trust and confidence that would have rendered his silence a fraud. So Chiarella doesn't go to prison. He's exonerated by our Supreme Court. But what the Supreme Court did is set up this classical theory of insider trading. If you are a trader, and we'll see in a moment, if you are the tippy of a trader, if you are an insider, or you are a tippy of an insider, and you owe duties to the person on the other side of the transaction, then you've committed fraud under Rule 10b-5. Okay, that took a long time, and so your students think that pulling parts from a statute is complicated. Learning about this through case law and these doctrines that a court does presents its own challenges for sure. So the paradigm then that it's the fiduciary relationship between the insider and their counterparty on the other side of the transaction certainly explains the result in Texas Gulf Sulfur, because as I said, those were true insiders, officers, directors, employees. But think about the limitations of a theory like that, if that is exclusively your insider trading theory. All sorts of information can be unlawfully obtained and traded on, but unless you owe that fiduciary relationship to shareholders on the other side of the transaction, Rule 10b-5 may not cover you. So ironically, even insiders of a corporation, true insiders, officers, directors who are in the know, they can take that information under the classical theory, and if they're just smart enough to buy stock in another company, not their own, they get scot-free under the classical theory as well. So it didn't take the SEC and federal prosecutors long. I should say that, like in Australia, insider trading is both a civil offense, and if there's a willful violation in the United States, it can be prosecuted criminally. So the Second Circuit began to accept the misappropriation theory of insider trading. And eventually then in 1997, the US Supreme Court endorsed this alternative theory of insider trading. But this theory too has fiduciary obligations at the source. So here's the misappropriation theory. The misappropriation theory is someone who stands in a fiduciary-like relationship will commit fraud if that person seizes from the source of the information, who is a principal, the information for personal benefit. And so who's the party you're defrauding? You're not defrauding the person on the other side of the transaction. You're essentially defrauding your employer. And so in the Chiarella printer case, under the misappropriation theory, he would have gone to prison, because even though he was a stranger to the target shareholders, he owed a fiduciary obligation to his printing company and to the printing company's client, which was the acquiring corporation. And so the fraud in the misappropriation theory is not the breach of the duty of loyalty to your employer per se. It's that that relationship creates disclosure obligation, that your silence to your employer is what is the Rule 10b-5 fraud. And so that's our doctrine in the United States, that you either owe a fiduciary obligation to the person on the other side of the transaction under the classical theory, or you owe a fiduciary obligation to the source of the information and you defraud the source. Now, in the US versus O'Hagan case that I mentioned, that the Supreme Court endorsed this, Justice Ruth Bader Ginsburg wrote the majority opinion. And this was a very controversial decision at the time, because this is employer-employee relationship in some ways, not really the securities market. And what she said is that, yes, the fraud is on, in that case, it was a law firm, because O'Hagan was actually an attorney, clearly knew better, and took client information to buy stock in the target companies. His firm represented the acquiring company. Justice Ginsburg in the O'Hagan case says that the entire Securities Exchange Act provision and Rule 10b-5 in particular can be read broadly, because one of the animating purposes of the federal securities laws was to foster market confidence and market integrity. And so she said that that policy allows us to read Rule 10b-5 broadly to prohibit this type of fraud on the source. The last part of the US doctrine that I'll take time to explain is what happens to tippies, because tippies are almost always by definition strangers to everyone connected to the information. Tippies, that is, an insider shares information with a buddy or a friend or a relative. The relative, the buddy, the friend doesn't owe any duties to the shareholders if it was an officer or director who shared the information. And certainly had O'Hagan in that attorney case prosecuted under the misappropriation theory, had O'Hagan shared the information, the confidential client information, and had someone else traded on it, that did not happen in the case. It was a bad case, but didn't go down that road. The person who received the information wouldn't owe the law firm a fiduciary duty and wouldn't owe the law firm's client a fiduciary duty. So what do you do then if your entire doctrine is grounded in fiduciary principles? You get out your thinking caps and you invent another theory. And that's exactly what the Supreme Court did in 1983 in the Dirks versus SEC case. What the court said there is that tippies of insiders, including temporary insiders like accountants or lawyers or investment bankers, tippies of insiders are derivatively liable under Rule 10b-5 when the insider receives a direct or indirect personal benefit from the tip. And so it's the expectation of a personal benefit. If the buddy says, I'm going to split the profits with you, and doesn't, and runs off to New Zealand and spends all the money, that's still enough of a personal benefit to trigger liability, because the insider who shared the information was expecting the quid pro quo there. So now remember, though, that it's all about disclosure. And so what we're essentially creating is the legal fiction that stranger tippee owes a duty to the shareholders on the other side of the transaction in a classical tipping case, or that stranger tippee owes a fiduciary disclosure obligation to the source of the information in a misappropriation case. And in Salmon versus the SEC, which was our Supreme Court's last say-so on insider trading, even though it didn't explicitly decide the personal benefit test was a necessity, it assumed it was. And so, and we all of us who taught this for years assumed it as well, that the personal benefit test applies to both the classical and the misappropriation theory. Now, last thing I'll say here is, what happens if the tipper doesn't receive a personal benefit? In the United States, then there's no offense that's committed. If the tipper just no offense under the federal securities laws. Corporate state law would say you still would breach your duty of care, and there's all sorts of other sort of bad state law things that can happen to you. But if you are a director of a company and you just happen to let it slip that you're involved in a merger and acquisition, that would not be enough to trigger the personal benefit test. And therefore, the lucky recipient of your slip of the tongue would too be not liable under our Rule 10b-5, unless if it's a tender offer, and I won't go down that route, we have a special insider trading rule, Rule 14E3, that is a broader prohibition than Rule 10b-5. So I tell my students, if you are in a bar and you overhear information by two insiders, well, I don't tell my students this. Let me rephrase this. My students ask me the question, if I'm in a bar and I overhear two company executives talking about a breakthrough drug, can I trade on that information? And the answer in the United States is yes, you can. It's not a tender offer, so it doesn't fall under that special. And you just happen to be lucky. Now, I also tell them, because I know this is recorded, and so it's really important for any student listening, I also tell my students that while legally overhearing information and trading on it is not an offense typically in the United States, if you're in the law firm and you do something like that, your law firm is going to have to undergo, they're going to find you and they're going to try to figure it out. And no law firm likes to answer interrogatories about how you might have been in a bar and listened to information. And so, so that's the lesson for all those listening out there. So We're back to Australia now. And so Juliet's going to talk about fiduciary duties in Australia. And
Thank
I'll step
you.
back a little
And
bit.
I will say that, to my students' distress, when they ask me similar questions, the response is, yes, if you overhear two people in a bar discussing their pharmaceutical discovery and you trade on it, you absolutely are in breach of Australia's insider trading laws. Doesn't matter if those insiders didn't know that you were listening. Doesn't matter if they don't realise you overheard them. If you hear that information, you know that it's influential, it's material. That's why you want to rush off and trade. You know it's not publicly available. They're having their private discussion. If you trade on the basis of that as a tippee, absolutely you have potential liability. Now, then my students will say, well, how would the police ever find me? How would ASIC ever find me? Gathering evidence is an entirely different lecture, and we can talk about that separately. But in the corporate crime class that I teach, I find the students are in two groups. And I always say to them at the beginning, why have you enrolled in this unit? And the first group are there because I really want to know the ethical thing to do. I really want to do this. And there's other students who are like, yeah, I want to know exactly where the line is on what's illegal and what's not legal, or what is legal. So back to the Australian position. And this is where we're going to talk a bit about whether there's any consideration of fiduciary duties in Australia when we look at insider trading laws. So as we're talking about before, insider trading here is prohibited not because of any requirement that there be a fiduciary relationship. There's no requirement for any particular personal connection. The only relevant connection is that someone has the information and that the other elements that fulfill the information has the relevant qualities and they're aware of that, and yet they still trade, procure or tip. As a matter of history, and this is where sort of the US and Australia are sort of in some ways a little bit juxtaposed. Australia originally did have a distinction that was made in legislation between primary and secondary insiders when insider trading was first prohibited, and that has long since been abolished. And when I say long since, in the 1990s. So to some of you, that's before you were born. It's ancient history. To others of us, losing my ability to speak, which isn't good in a lecture. For the rest of us, that's a time we remember quite well. It might not seem that long ago at all, but there's only an information connection. But what is really interesting when we look at some of the cases, even though there is no distinction in the legislation now between a primary or a secondary insider, no consideration as to how you came about the information. Some of the cases draw a distinction or make a point that certain people are true insiders. And one of the first cases to really make this distinction is one that I'm sure a lot of you will know or remember, which was Rivkin's case. And in that particular case, Mr. Rivkin, a very well-known Sydney stockbroker, was selling his mansion in the eastern suburbs, and Mr. Doff, the second reference there, was his real estate agent. And the buyer of the property, or the prospective buyer, I should say, he didn't end up buying it. The prospective buyer wanted to have a really, really long settlement, wanted to buy the property. And Mr. Rivkin, quite naturally, was saying, well, why do you want to take so long to settle on this house? And the prospective buyer was actually the executive chair of Impulse Airlines, which now no longer exists. And he actually said to Mr. Rivkin, in Mr. Doff's presence as well, Qantas is going to buy Impulse and it needs ACCC approval, and that has to go through before I'll have squillions of dollars to buy this house. And he supposedly then said to him, now that you know this, you can't trade in Qantas shares. What happened the next day? Both Mr. Rivkin and Mr. Doff bought a parcel of Qantas shares, which then, when it was announced publicly that Qantas was doing a deal with Impulse, the shares went up a little bit. They actually didn't make a very big profit at all. I think Mr. Rivkin made about $3,000 through a corporate structure. His own personal entitlement was about $300. Mr. Doff also made quite a modest profit on the transaction. We'll talk about whether the amount you make is relevant shortly. In that particular case, they were both, in each of those two cases, they were both convicted, but The judges in each of the cases made a real point that neither of them in those circumstances, despite the fact that Mr. Rivkin was a stockbroker, had clearly detailed knowledge of the market, would clearly know the types of information that would be price sensitive to a company share price, neither of them were true insiders. They came across the information in an unrelated setting, in the personal setting of trying to sell a house and not actively trying to seek the information. It was sort of fell in their lap. Now, Mr. Rivkin, as part of his defence, had discussed the fact that he was going to buy Qantas shares anyway. It was all just a huge coincidence. That was irrelevant. He possessed the information. He knew it was price sensitive, traded in the shares. He was found guilty of insider trading. But when he was being sentenced, the court made a very big deal about the fact that it wasn't the worst type of conduct, and it wasn't the worst not just because the profit was very modest, but because he was not a true insider. And the same for Mr. Doff. The legislation makes no reference to whether having a close relationship to the company or any relationship is relevant at all, but the court emphasised this point significantly. We then saw that again in 2013 in Khoo's case. So in Khoo's case, he was working in a investment bank and had passed some information to his friend. And the court makes the point that that was more serious than the conduct of his friend he passed because he was a true insider. He owed a fiduciary duty to his employer. It was through his employer he got the information. It made it much more serious than the tippie's conduct. In Hull's case, he was the tippie, and even though the tipper was also prosecuted, who passed him information, they were jogging buddies. And the tippie had sort of tried to draw out from his jogging buddy information, and his jogging buddy actually was proceeded against, but it was found that he didn't know that his friend was actually trying to get information out of him, so he was able to avoid liability there. But when Mr. Hull was being sentenced, he got a very modest sentence. The court once again said he was not a true insider. Tippie's conduct is much less serious generally than a tipper's. And then the final example here, we'll talk about a couple of these shortly when we do a real comparison of tippies and tippers in some sets. Stephen Zhao was convicted of insider trading in 2018, and he received the longest sentence anyone has ever received in Australia, more than 8 years in prison for insider trading. And he was the managing director of a company that was trying to take over two other companies. One was Sundance, one was Bannerman, and his company that he was the managing director of was Hanlong. And he used information that he got because he was the managing director, knowing about these proposed takeovers, and then buying shares in those target companies that his own company wanted to take over. And the court was scathing in its comments about how a true insider like that, who owed significant fiduciary duties as a managing director, had engaged in this reprehensible conduct of insider trading. So we have seen in a number of cases this real emphasis when sentencing someone makes no difference to whether they have liability, they've still committed the offence, but when they determine the length of the sentence, being a true insider, someone who owes a fiduciary duty, is really seen as a significant aggravating factor. So establishing that, one thing we do need to acknowledge is that whenever anyone is sentenced in Australia, there's a whole number of factors that need to be considered, and that's for any particular crime. And the court needs to weigh up all sorts of things. Has the person pleaded guilty or not guilty? If they pleaded not guilty, did they do so really early on, or did they wait till the absolute last possible minute and they've still put the prosecution to proof? Have they got some circumstances that would mean that we would be more generous with them? Were they very young? Did they have significant, particularly in the case of insider trading, did they have significant personal financial circumstances that were very pressing and didn't see a way out? Have they got an addiction? Is there some reason that we would mitigate the conduct? And all of those things need to be balanced. So in that way, a number of the cases, it's really hard to just compare a sentence ordinarily and say, well, this person got 8 years and that person got 1 year. There's all these other factors. How much money did they spend? How much money did they make? How do we compare them? And that's why these sets of tipper and tippee cases have proved such a useful set for Donna and I, because we can see people whose cases have arisen out of almost exactly the same circumstances, and it makes them really useful for trying to actually do that comparison. And what we've found in Australia is that it is the tipper, the one who passes on the information, that true insider, who almost always will get a longer sentence. So the tippee is the one who has received that information. They're the one who has done the trading. They're the one who has used the information, gone to the market, bought some shares or sold some shares and either avoided a loss or, as in most of these cases, has made a gain. They're the one who gets the lesser sentence. The one who passes the information on, even if they don't trade themselves, they're the one that the courts are treating in almost all circumstances, with one notable exception, the most in the harshest way. So the first example I want to share with you here is one that is of quite recent history. So I'm sure most of you will be aware of the insider trading by John Hartman and Oliver Curtis. And I do need to give a disclaimer here, in that when Oliver Curtis was being prosecuted, I was a consultant to the law firm that was representing him. Did still go to jail. John Hartman and Oliver Curtis were very young men, only a few years out of high school. John Hartman was working for a securities firm, and he would get information as part of his job about very large trades that his employer was about to carry out for their clients. In fact, he actually was generally the one who pressed the button to make the trades happen. So he knew which trades were coming in, and because of the job he had, he would know which ones were likely to move the market. He and Curtis had an agreement that he would then pass not necessarily a lot of detailed information, but tell Curtis which shares were likely to go up or down. And Curtis bought derivative products in those particular companies, made lots of money. They actually got prosecuted at quite different times, and as you can see from the time difference, but over the same sort of circumstances. John Hartman, first of all, received a sentence of over 4 years in jail, which was reduced on appeal because of his personal circumstances to a 3-year term. Oliver Curtis, the one who engaged in the trading and made a lot of money, not all of it shared with John Hartman, received 1 year in jail. We see similar situation with Koo and Tan, where information's passed from the insider to the tippee. The insider receives, the true insider receives the longest sentence. Zhu and Zhao, we just talked about Stephen Zhao, who received the longest sentence. Zhu was a more junior employee in the company who wouldn't have had access to the information about the takeovers, but for the fact that his boss shared it with him, so he was regarded as a tippee and not a true insider, received a very, very short sentence. Hill and Kamei, Christopher Hill and Lucas Kamei, and a number of you will know about them, and you might have heard about them in a podcast that one of my colleagues in the business school, Professor Clinton Freed, participated in, The Sure Thing. Christopher Hill worked for the Bureau of Statistics. Lucas Kamei worked for the NAB, passed information out about changes that would affect the price of the Australian dollar. And the reason that Kamei appears to have received the longest sentence, despite the fact that he was the tippee, is that he actually engaged in all sorts of other wrongdoing at the same time: identity fraud, money laundering. Christopher Hill's primary misconduct was really just the passing of the information. We're going to pass back over to Donna. I think I've used up a lot of time there.
That's just so fascinating too. So in the United States, even though our doctrine is all about fiduciary relationships, our penalties and our sentencing is actually more a function of the market abuse and market harm often, not always, but often. So civilly, the SEC can seek a monetary penalty for either the tipper or the tippee, and Congress has authorized the SEC to seek in federal district court up to 3 times the profit gained or loss avoided by the insider trading. On the criminal side, in the United States, criminal sentences are drawn from the advisory federal sentencing guidelines, a very complicated calculus of a base offense and then ratcheting up and ratcheting down. But the primary driver of a ratcheted up prison sentence is the amount of money made by the crime. And so you can see in insider trading, in cases where the monies that are made, the profits that are made are in the hundreds of millions of dollars, sentences are going to go tremendously up. The sentences could be tippers as well as tippies, but for reasons that I'll describe in a moment, it sometimes doesn't work that way. So sometimes tippers are viewed as the more culpable party. And so it would be exactly like Australia in that instance. And the case that I'll just take 1 minute to less than 1 minute, 30 seconds to talk about, it has an Australian connection. Christopher Collins was a member of the US Congress, but he was also a director of an Australian biotech company, Innate Immunotherapeutics. And so it wasn't government information. He actually took bad news that he learned from the CEO of Innate and shared that with his son, who shared it with his fiance, who shared it with her father. And because it was bad news, they all sold their Innate stock before the bad news was publicly announced. U.S. prosecutors prosecuted Christopher Collins, prosecuted the son, the fiance's father. The fiance and the mother actually settled with the Securities and Exchange Commission. So they avoided about $700,000 in losses. When federal prosecutors prosecuted the case, so everyone settled, pled guilty. And so in the sentencing, the federal judge who's in charge of the sentencing pointed to Chris Collins and said, you violated your fiduciary duty to Innate Pharmaceutical. And because of your bad judgment, your son, fiance, father-in-law, all that. So you're the culpable party, and sentenced Chris Collins to 26 months, so a little over 2 years in prison. He then resigned his Congress seat. He's not in prison because President Trump, our President Trump at the time, pardoned him. And so he, enough. So anyway, that would be, yeah, don't get me started. So that would be lining up with how things are in Australia. But tippies in the US are often sanctioned much more harshly than their insider tippers. And the 3 cases I give there are all hedge fund cases where the monies made by the hedge fund traders were in the hundreds of millions of dollars. And in each of those cases that I have here, the Sacron case, the Newman case, the Martoma case, they were Newman involved earnings information, some good news, some bad news, that filtered down to hedge fund traders by insiders at Dell and insiders at NVIDIA, 2 computer type companies. And 2 streams of tipping. In the Dell case, the employee who tipped, and he tipped a friend, and that was a whole controversy. Was he a really good friend? Did he get a personal benefit? The whole deal. Is a Facebook friend a friend? And so, leaving that question aside, in the Dell case, there was no proceeding, civil or criminal, against the Dell insider who gave the tip. In the NVIDIA case, the insider who tipped a friend got a $30,000 civil penalty. Well, what happened and settled with the Securities and Exchange Commission? What happened to the hedge fund traders that made the $100 million? Well, they were originally they were originally sentenced to 5 years and 7 years in prison. Now, the Second Circuit ended up overturning the jury verdict and the sentencing in those cases because of the personal benefit issues that I shared with you. But if our concern is on insiders who breach their fiduciary duty, 30,000 penalty, not so much. The less culpable, maybe, tippies, 5-7 years in prison. And so the Martoma case and the Newman case, the Martoma case and the Sakharov case, both of the tippers there were doctors. And I tell all my doctors friends, if you're doing a clinical drug trial, don't talk to people, and certainly don't talk to your hedge fund friends. And, you know, so, but that was the instance there. Michael Martoma, based on information that a doctor doing a clinical trial, that was bad news about an Alzheimer's drug, made $275 million for his hedge funds. And so he was sentenced to 9 years in prison. And his tipper, months, basically. And again, part of this is prosecuting the case. Often the tipper works with the government in fessing up. And so there's cooperation credit. Chip Sakharov made $30 million. This was a hepatitis drug bad news case. And, you know, his doctor there, again, just a minimal criminal sentence. The trader gets 5 years in prison. The sentencing judge, and so the sentencing judge in the Chip Sakharov case says to him at sentencing, because he pled guilty, you caused investors to lose money. You undermined market integrity. But notice what his crime was. His crime was that he didn't disclose to the doctor didn't disclose to the hepatitis drug manufacturer that they were loose lips and leaking out. And so that was the fraud there. So last I see that we're getting the hook. So I'll wind up with the penalty paradox. You know, one might expect the insider trading penalties in each country to be meted out according to the legal doctrine in place. But in the US, the victims of insider trading violations are the ones owed the fiduciary obligation, but often the extent of the marketplace harm is what fuels the harsh penalties. The hundreds of millions of dollars made by hedge funds, and therefore the hundreds of millions of dollars theoretically lost by investors, and the market harm is what often gets the 5, 6, 10 years in prison. In Australia, violations are premised on a market integrity rationale. And so you would think maybe that, you know, when there's a lot of market abuse, you go up the river for the market abuse. But that's not what happens, because it's often the fiduciary tippers who receives the hard sentence, even when the gains made or the losses avoided are minimal. And so Juliet and I have lots of questions and future directions, but those are questions that we're asking ourselves, and I won't take a moment to actually ask them in this context. Instead, I think Tim is going to invite questions from our very patient audience. So thank you all very, very much.
Well, thank you, Donna and Juliet. I just find it fascinating that you have two systems of law that superficially are just like chalk and cheese, and yet through your comparative analysis, it sheds light on that penalty paradox that you just talked about. It just shows the value of comparative research in this area. So I'll open the floor now for Q&A. The one thing I need to mention is I'll have to repeat the question for the recording. So yeah, thanks.
Thank you. This may have been addressed earlier, so apologies if I missed it, but there are obviously a lot of circumstances where corporations don't necessarily comply with their disclosure obligations, but there actually might be insider information that never makes it out. And some of that information would be quite adverse for investors and also securities. I'm not aware of any authority to this effect. It's from the courts in the US and Australia, but to what extent would a tipper or a tippee actually be acting in the public interest by increasing market efficiency, by putting information out there through their trade that was never going to be disclosed and ought to have been disclosed in line with the securities laws?
So the question was essentially, are there any circumstances in which a tipper or a tippee might be found to be acting in the public interest by creating information flow for the market?
And the extent to which something like that could be arguable as a defence. I'm not aware that it's been run before, but I'm very curious.
I'm happy to go first and talk about the Australian position. So first of all, I commend your creative thinking, and it's a type of thing my students, sometimes try to grasp with as well. So if I'm understanding correctly, you're saying a company's got a continuous disclosure obligation, as we all know they should do, if they're aware of information that's going to affect the price or value of their securities, but that for whatever reason they haven't notified the exchange, but someone who's internal to the company is aware of the information. So we haven't really talked about the market efficiency arguments today. There are some scholars who think that insider trading shouldn't be prohibited because they think that insiders actually, by their trading, assist in creating an informed market. Now, I don't follow that at all. The best thing an insider can do is they should abstain. And if a company is not compliant, they should be calling the ASX and saying this particular company deserves to have a call from your market surveillance team. The issue with suggesting that someone is helping the market by their trading is it actually really going to be a big enough trade to move the market in the right direction anyway? Lots of small trades might give them enough profit that they think was worth their while.
Not only work for hedge funds.
Oh, if you can invest a squillion dollars in it and make a giant profit, you'll move the market in the right direction. Is that really fair that other investors who, if they'd had the information, would have made a different trading decision? It wouldn't be. I don't see that flying as a defence here, because the obligation on the insider is to abstain. So it's not I don't see a way to make that a work as a defence. Perhaps, unfortunately.
And that would be the same in the United States. I mean, so one of the huge differences regarding securities disclosures between the United States and Australia is we do not, in the US, have a continuous disclosure obligation for our companies. That is, in the US, you can keep secrets. You certainly have to disclose when your quarterly reports are filed with the Securities and Exchange Commission, when your annual reports are filed with our Securities and Exchange Commission, as long as there's a line item that picks up that information. But we keep a lot more legal secrets in the US than Australia does. Now, what we have is Regulation FD, Regulation Fair Disclosure, that says if you disclose to some or selectively, you must disclose to all. So you can't whisper to analysts or whisper to hedge fund. But the debate about market efficiency in the US has been going on since 1960s, when Henry Manny, the law and economics, or one of the law and economics kings, wrote a book in defense of insider trading. And I think what I have found impressive is that a number of scholars in the United States have taken that market efficiency and have actually said, whatever marginal gains we might see, even among hedge funds that can move markets, whatever marginal gains we can see for trading is more than outweighed by the inefficiencies that occur when brokerage firms and other professional traders fear unregulated insider trading and widen the bid-ask price of stock. And so, whatever you might gain in market efficiency, you lose bigger. people will say. And I must say that's where I fall on the efficiency side of the debate.
Yeah. All right. I'm conscious that we've gone over the advertised finish time, and I was under reasonably strict instructions to bring the formal proceedings to a close around then. But wait, there's more. We have refreshments at the back of the room. So what I might do is bring the formal proceedings to an end now, and we can continue the conversation over some food and drinks afterwards.
That sounds wonderful.
But before we do that, can we please thank Professors Navy and Evelyn?
And thank you, Tim, for
Thank you. All right. Let's gather at the back.